Hi, my name is Martin Sandoval Chavira, and I'm going to talk about international humanitarian law. What is it? It's a law that regulates the conduct of war. It's a set of rules which seek for humanitarian reasons to limit the effects of armed conflicts. International humanitarian law is part of international law, which is the body of rules governing relations between states. Has its roots in the after the Second World War when it's created the international humanitarian law to regulate the armed conflicts. International humanitarian law can be found in the Geneva Convention of 1949. International humanitarian law applies to every single armed conflict, but it does not cover internal tensions or disturbances. The law applies only once a conflict has begun. The international humanitarian law covers two areas. It covers the protections of those who are not or are not longer taking part in the fight or in the war, and the restrictions on the means of warfare, in particular weapons like biological weapons or chemical weapons. It also helped to establish restrictions about weapons and tactics used in the war, like to fail to discriminate, cause superfluous injury or unnecessary suffering, cause severe or long-term damage to the environment. International humanitarian law has 6 principles that helps to regulate the war between states. The first one is distinction, which it consists that you must always clearly distinguish between combat soldiers and civilians. This in order to preserve the not killing civilians and to difference civilians and people that are soldiers that are fighting actually in the war. The second one is limitation, which consists that weapons and tactics that are of a nature to cause unnecessary suffering or superfluous injury are prohibited. The purpose of the second sentence of this principle is to prohibit weapons which cause more suffering or injury than is necessary to put enemy combatants out of action. The third principle is good faith. Good faith between opponents is a customary principle of warfare. The military should show good faith in their interpretation of the law of armed conflict. The fourth one is military necessity, which consists that every soldier can do every single thing in their power to protect themselves and to fight against the enemy, but it has to be in between the parameters that to not make unnecessary suffering or injury to the enemy. The fifth one is proportion, which consists that the war has to be fair. In order this that it has to be a proportions between the weapons that are which every state is fighting with. So, for example, if some state is using weapons, the other state cannot use nuclear weapons. The last principle is about human treatment and no discrimination, which consists that every single person in the world needs to respect above everything the human rights. And for example, if someone needs medical treatment, take that person to the hospital or give him food or water, etc. Humanitarian law is important because it helps to take the measures that are necessary in order to protect the states and the people, so the war or the conflict is not so extreme or dangerous to the civilian and to the people in general. It also helped to take measures have also been taken at an international level. Tribunals have been created to punish acts committed into recent conflicts, for example, the former Yugoslavia and Rwanda. An international criminal court with the responsibility of repressing inter-allies war crimes was created by the 1998 Rome Statute. Thank you very much for your attention. I hope you like it. Thank you.